Welcome students. I, Advocate Supriya Sood, welcome you all to the second session on the POSH Act. Here in this session, we will learn about the remaining basics of the POSH Act and we'll see certain important court cases which will help us to understand what we have studied till now on the POSH Act. So let's start session. In this session, we will see the confidentiality obligations, the penalty for breach of confidentiality obligations, punishment for false or malicious complaint or evidence, appeals, right of appeal to be filed, what are the duties of the employer, how the annual report is filed, and we will also see certain important court cases. Under the POSH Act, the law mandates strict confidentiality of all information related to sexual harassment inquiry proceedings, right from filing of the sexual harassment complaint till the action taken by the employer on the recommendations of the internal committee. The law says the following shall not be published, communicated, or made known to the public, press, or media in any manner whatsoever. In any manner would mean under any circumstances, through any mode or medium, or related to any matter whatsoever. The acts or the details which are debarred from disclosure are: number 1, contents of the complaint; number 2, identity and addresses of the aggrieved woman, of the respondent, and of the witnesses from both the sides; number 3, any information relating to conciliation and inquiry proceedings; number 4, recommendation of the inquiry committee, and what action has been taken by the employer basis the recommendation of the IC. All these things have to be kept strictly confidential. Please note that employer has a right. The law gives the employer a right. However, while disseminating such information regarding the justice secured, the employer or any person who is entrusted with the responsibility of maintaining the confidentiality should not disclose or mention or state in any manner whatsoever, either verbally or in writing or through any mode or medium, the name and addresses of the aggrieved woman and of the witnesses, or any other, should not disclose any other identity or any particulars which can lead to identification of the aggrieved woman and witnesses. Now let's see what all penalties are provided under the law in case the person who is entrusted or who is liable or is under legal duty to ensure confidentiality. Law says, whosoever is entrusted with the duty to handle or deal with the complaint, inquiry, or any recommendation or action to be taken breaches his or her confidentiality obligation shall be liable for penalty in accordance with the provisions of the applicable service rules which are applicable on such person. Please note, even the IC members are also included in this. IC members do not have any immunity from the penalty or from the penal provisions. They are also liable to maintain the strict confidentiality. And where the service rules are not applicable or do not exist, then employer shall have a legal right, or we can say a legal duty, to recover a sum of rupees 5,000 from such person who has breached his confidentiality obligation. Students, till now we have seen that, or we have assumed that whatever complaint is filed by the aggrieved woman or by a complainant are genuine cases. But what about cases where the woman purported to be an aggrieved woman or a complainant files a malicious complaint, knowing it to be false without believing in its truth, or any witness gives false evidence to support the case of an aggrieved woman, purported aggrieved woman? Then what all punishments can be leveled upon them? Where the IC arrives at a conclusion that allegation against the respondent is malicious, or the complaint against the respondent is malicious, or aggrieved woman or any other person making the complaint has made a complaint knowing it to be false or to support her case has produced any forged or misleading document, then IC can recommend to employer to take action in accordance with the provisions of the service rules applicable upon the aggrieved woman or the complainant. However, in case where there are no service rules, then IC can recommend to the employer to take any of the following actions, which can be a written apology, a warning letter, issue of the warning letter, reprimand or censure, withholding of promotion or pay rise or increment of such person or a complainant or aggrieved woman, termination of such person, whether aggrieved woman or a complainant, from service, or asking her or him to undergo a counseling session. Similarly, if any person stands as a witness and gives or records false evidence in favor of the aggrieved woman or complainant, then and IC arrives at the conclusion that yes, false evidence has been given by any person, then IC again can recommend to the employer to take the action against the witness as per the applicable service rules, and in case no service rules exist, then again the action of asking a witness to give a written apology or issue of the warning letter, reprimand, censure, withholding of increment, promotion, pay rise, or termination from service, depending on the severity of the false evidence or the false case which is made out, it will all depend on that termination, or asking the witness to undergo a counseling session can be done. Please note that here also, employer, before he imposes any penalty, has to ensure that principles of natural justice are followed. An opportunity is given of being heard to such aggrieved woman or a complainant, or to a witness who allegedly or has given a false evidence in case of a witness, or who has filed a malicious complaint or has filed a complaint against a respondent knowing it to be false, or has of course filed any misleading or a false document. Now, as we have seen in the previous session, that most of the sexual harassment cases happens in the closed rooms where there are only two persons available, one the aggrieved woman and other the respondent. Now in such cases, it's quite difficult for an aggrieved woman to bring the evidences or to bring the witnesses. Now, in case she unfortunately fails to substantiate her complaint or to provide enough proof which can enable the IC to arrive at any conclusion, then will she be punished or any penalty can be imposed upon her under the pretext that she has filed a false or malicious complaint? The answer is no. The law says mere inability to substantiate a complaint or provide adequate proof will not attract any adverse action against the complainant, because false or malicious complaint or giving a false evidence is deliberate act, is intentional act, where the complainant or a person standing as a witness knows that whatever he or she is stating is false or does not believe in its truth. However, mere inability to substantiate a complaint or to provide adequate proof or evidence does not mean, or inability to produce any witness does not mean, that complainant or the aggrieved woman has intentionally filed a false or malicious complaint. Now comes, after the action has been taken or any penalty has been imposed either on any person or on the employer, then is it an end of a legal route for such respondent or a complainant if she thinks that decision should have been the other way, or any person upon whose penalty has been imposed? No, such persons, whether complainant or the respondent or any person upon whose any penalty has been imposed, even the employer, a person aggrieved from the IC's recommendation or punishment imposed on him, or for non-implementation of the recommendations, can file an appeal within a limitation period of 90 days to an appellate authority or to a court or a tribunal. One of the important objective of the POSH Act was to impose certain duties on the employer so that the act merely does not remain a formality. It helps in prevention, prohibition and redressal of the complaints also. Therefore, every employer has a duty to provide a safe working environment, including safety from persons coming into the contact at workplace, also to formulate and display the POSH policy, display at various places in the workplace penal consequences of sexual harassment, also to display in the workplace order constituting the IC along with the names and addresses and contact details of the IC, to organize workshops and awareness programs at regular intervals for the employees, to sensitize them with penal provisions and their of the applicable under the POSH Act, and to make them aware about their duties and responsibilities, to organize orientation programs, training programs and capacity building programs for the IC, provide necessary facilities to the IC to produce any witness or ensure the presence of the respondent, to help the IC or the woman to file a criminal complaint under the Bharatiya Nyaya Sanhita or any other applicable law. Previously it was Indian Penal Code, now it is Bharatiya Nyaya Sanhita 2023, and to monitor timely submission of the annual report. The IC, along with the employer or in addition to the employer, too has a duty to submit the annual report wherein the number of the complaints received in a year will be mentioned, number of complaints disposed of will be mentioned, number of cases pending for more than 90 days will be mentioned, number of workshops or awareness programs carried out and nature of action taken by the employer will be mentioned. Number of cases pending for more than 90 days. Why? Because IC is under duty to complete and conclude the inquiry within a limitation period of 90 days. If it fails to do so, then number of cases which could not be closed or concluded within a limitation period of 90 days must be mentioned in the annual report. Similarly, employer will also include in his annual report number of cases filed and their disposal under the POSH Act. And if the employer is a limited company or a private limited company, then this report will also form part of the director's annual report as well. Now students, after understanding certain important basics of the POSH Act, let's come to certain landmark judgments. In one of the case, the respondent, who was a woman, challenged the decision of the IC on the ground that POSH Act is not applicable on the same gender respondent. That is, if the gender happens to be a woman or the respondent happens to be a woman, the POSH Act will not be applicable. The Honorable Calcutta High Court has held that the word used in the POSH Act is a person. A person can be of any gender, including a woman. Therefore, same-gender sexual harassment complaints are maintainable under the POSH Act. The Honorable Court has said that sexual harassment, as is contemplated under the POSH Act, does not mean that person of the same gender cannot hurt the modesty or dignity of a woman. The term respondent, which is defined in the law, brings within its fold or ambit a person, including persons of all genders and members of any gender, even interse. Therefore, please note that respondent can be any person, not necessarily merely a man or a male. She can also be a woman or person of any gender, including a third gender. Let's look at another case. In one of the cases, the complainant verbally complained to the IC about purported or alleged harassment, sexual harassment. Not the sexual harassment, but the harassment. It was merely a verbal statement given to the IC, wherein she verbally alleged a rude behavior by the owner, by the director of the company, devoid of sexual behavior or actions or acts, and unfair labor practices while terminating her from service. And IC took cognizance of her verbal complaint, purported complaint, and without giving an opportunity of being heard, without following the principles of natural justice, as we have seen, proceeded to hold the respondent liable for the purported or alleged acts of harassment, sexual harassment here. The harassment means the sexual harassment. The respondent challenged the decision of the IC. The Honorable Kerala High Court reiterated that there is a mandatory requirement of a written complaint which has to be filed. Without a written complaint from the aggrieved woman or from a complainant, IC cannot take cognizance of any verbal complaint. It is mandatory, it is essential, it is must that IC will have jurisdiction, will have authority to adjudicate cases under the POSH Act only if the aggrieved woman or complainant has filed a written complaint. Section 9 of the POSH Act, read with Rule 6 of the POSH rules, mandates a written complaint. It is a mandatory requirement. IC cannot overlook it or cannot waive off or dispense with the requirement, this mandatory requirement of a written complaint. Further, the Honorable Court has said that whatever the purported complainant has alleged, these were merely the normal labor disputes, does not come within the jurisdiction of the IC and thus are not covered under the POSH Act. For example, hostile work environment, unfair labor trade practices, without having any element of sexual harassment, cannot be treated as POSH cases or cases of sexual harassment under the POSH Act. Further, the Honorable Court has held that denial of cross-examination opportunity or right to the respondent violates principles of natural justice. As we have already seen in the previous slide, that IC will conduct the inquiry proceedings in compliance with principles of natural justice. That is, giving an opportunity to the respondent to be heard, to present his witnesses, to present his case or defense, to cross-examine the witnesses of the complainant or the aggrieved woman. Here in this case, no opportunity of cross-examination was provided. Thus, court held that any decision of the IC is null and void, has no legal effect. Let's come to the third case. One of the respondents, who was a colleague of the aggrieved woman, was regularly commenting on the dress-up choice of a woman colleague. The woman colleague initially ignored such comments, but later, when it became a series of complaints, series of incidents, filed a complaint before the IC, a written complaint. When the notice was issued to the respondent, in his defense, in his reply, he contended that he thought his behavior, his act of passing the comments on the dress-up style or choice of the aggrieved woman to be quite decent and friendly. And he thought that his comments will not make a woman colleague uncomfortable. The Honorable Madras High Court, however, held that under the POSH Act, what has to be looked at is not what the respondent thought was decent or acceptable, but how the respondent, a woman, thought it to be. Whether a woman thought such comments to be decent or acceptable or not, and whether the comments of the respondent made a woman feel uncomfortable. If a woman is not comfortable or does not find comments of the respondent to be decent or intimidating or scares her, then the case will definitely fall under the POSH Act. The Honorable Court said, if any comment, action or gesture is not received well by the woman, is thought to be inappropriate by the woman, which she feels as unwelcoming behavior, such comment, action or gesture will definitely fall within the definition of the word sexual harassment. Any gesture or comment which puts women in an embarrassing or uneasy position has to be treated as unwelcome gesture or comment within the meaning of the POSH Act. The Honorable Court said, if something is not received well by the woman, which she thoughts it to be inappropriate and feels that it is unwelcome behavior or act, the Honorable Court said it would fall under the definition of the word sexual harassment. Therefore, what a male or a respondent, let's not use the word male only, because as we have seen, the term respondent means a person of any gender. Therefore, let's confine ourselves to the word respondent. It's not necessary that any comment, action, behavior, act of the respondent which such respondent thinks is appropriate should be taken as a final word. It is the woman who has the ultimate right to decide what makes her uncomfortable, what she believes to be a bad touch or inappropriate or a comment which she does not like to listen, and such act or behavior or gesture of a respondent will definitely be termed as sexual harassment. In one of the cases, we have seen in the previous slide the limitation period provided under the law to file a complaint by an aggrieved woman. The limitation period provided under the law is 3 months from the date of the incident, and in series of incidents 3 months from the date of the last incident. However, we have seen that IC can extend the limitation period by another 3 months if aggrieved woman files a condonation of delay application, giving therein the sufficient or satisfactory reasons for delay. So the maximum period provided under the law is 3 plus 3, that is 6 months. In this case, the aggrieved woman had filed a complaint before the IC after 8 months from the date of the incident, and she has also filed a condonation of delay application citing the administrative inconvenience or the reasons. However, the Honorable Supreme Court of India held that sexual harassment, as is alleged by the respondent, is time barred, as the alleged incident happened in April 2023, but the complaint was filed in December 2023, that is after a maximum statutory limitation period of 6 months. The Honorable Supreme Court had held that the act of harassment which allegedly took place in April 2023 was a complete act in itself and did not continue thereafter. The administrative measures or inconvenience that is being cited as a reason by the complainant were independent of the harassment act, which might have caused certain inconvenience to the applicant, to the aggrieved woman, but they definitely were not part of the continued act of the sexual harassment or series of the acts of the harassment. Therefore, the Honorable Supreme Court dismissed the complaint as time barred. Therefore, students, it is necessary that complainant should be aware of the fact that complaint has to be filed and must be filed within the limitation period of 3 months. They should not wait for further time or on the assumption that IC will by right or by duty, by obligation, will extend the period. Let's see another case where the employer refused to provide a copy of the inquiry report to the complainant. The Honorable Supreme Court of India, in this matter where the complainant was not provided a copy of the complaint, imposed a penalty of 25,000 rupees on the employer for failure to provide a copy of the inquiry report, stating that complainant falls under the term concerned parties under subsection 1 of section 13 of the POSH Act. Honorable courts observed that there was a procedural violation as the petitioner came under the ambit of concerned party under subsection 1 of section 13 of the Act. Since it was an admitted fact that report copy was not given to the petitioner, the Honorable Court directed the imposition of rupees 25,000 as penalty on the employer. The Honorable Court recorded that on the facts of this case, where the inquiry report was not has not been provided or given to the petitioner, there has clearly been a violation of Section 13 of the Act. We therefore impose a penalty of rupees 25,000 which will be given to the petitioner by the employer. Let's see another case, students. Respondent who participated in the inquiry proceedings, who never objected to any of the inquiry proceedings, including the constitution or formation of the internal committee, challenged the constitution of the internal committee after he received an adverse order against him. While deciding this case, the Honorable Bombay High Court has ruled that once an employee has voluntarily participated in the proceedings before the internal committee under the POSH Act 2013, he cannot later on challenge the validity of its constitution or as not properly constituted because the outcome of the inquiry is unfavorable to him. Therefore, it is mandatory for the respondent, in case he wants to take any objection, he must take at the first possible opportunity, at the trial stage only. In the appeal, no new objection can be taken. The law does not permit any person to challenge the valid decisions or valid judgments or valid recommendations merely basis that the outcome of the inquiry is against him or her or against his or her interests or has not come up to his or her expectations. Therefore, it is necessary that whatever objections, whatever disputes you want to raise as a complainant or as a respondent, kindly do it at the trial stage before the inquiry committee itself, because later on the honorable courts will merely look into the maintainability of your appeal and whether properly the principles of natural justice have been followed or not, or whether the inquiry proceedings were fair or not in compliance with principles of natural justice, and so on and so forth. No new grounds will be allowed or permitted to be taken unless you can demonstrate to the full satisfaction of the Honorable Court that such new grounds were not within your knowledge at the time when proceedings were conducted before the IC. So students, with this we come to an end. I hope that certain or important basics of the POSH Act are absolutely clear to you, along with certain judgments that we refer to, which has made our understanding more clear and better. Thank you so much for attending these two sessions, students, and I wish you all the best. Thank you very much. God bless you all.